Swayam Prabha. Digital India. Educated India.
So, friends, while we are talking about the power of the court and the power of the judiciary as defined and laid down by the Constitution of India, and while we see that the judiciary can actually supervise public administration, it can review the activities of public administration, it can check abuse of power of the public administration. You will notice that because it is considered as a court of record, the Supreme Court uh, records are kept perpetually, and it's kind of something of an evidence for the future generation and the future administration of the country. Once the Supreme Court has laid down a law, it cannot be challenged in any other form because that is the finality. Though we say that within the Supreme Court there is a review that is possible. For example, in the Supreme Court, if a divisional bench, that is a bench of two judges, gives a judgment, it can be probably asked to the court to review it before three judges. If that also is not something that is satisfactory, then it can be referred to a constitutional bench. And in the current times, the constitutional bench consists of five judges. Apart from that, interestingly, you will notice that the Supreme Court, to render justice or to correct any kind of injustice, as the case may be, has designed something of its own called the curative petition. A curative petition is something that is allowed to cure any kind of miscarriage of justice. So, despite uh, exhausting all the reviews within the Supreme Court itself, if again the citizens or a group of victims would want the Supreme Court to revisit the case, then a curative petition can be filed before the court. So, this kind of legal precedent that is laid down by the Supreme Court is the law of the land. It is kind of a legal reference for jurists, scholars, and others. And hence, the orders or directions of the Supreme Court are supposed to be followed, and there is no choice in this matter. That is the reason why the contempt powers are given to the court. And you will notice that in case there is what we call as willful disobedience of any judgment, order, or writ, or any other process of the court, or if there is a willful breach of undertaking given to the court, then we would say that it is a civil contempt. Whereas if someone publishes of some kind of scandalous matter of a court or of a judge, or someone tries to lower the authority of a court or a judge, someone who prejudicially interferes with the due process of judicial proceeding, or someone who involves himself or herself in the interference or the obstruction of the administration of justice in any manner will face what is known as criminal contempt of court. However, please note innocent publications and distribution of fair reporting and accurate reporting of judicial proceedings, fair and reasonable criticism of the judgment, not of the judge, uh, are something that are permissible under the freedom of speech and expression, and they would not amount to any kind of a contempt of court. So you do have the right to comment, but you do not have the right to defame or bring down the dignity and the and the majesty of the court, as the case is. Now, interestingly, in case of criminal contempt of court, you can face a imprisonment up to 6 months or a fine of 2,000 rupees, and the Supreme Court has the power to punish. Uh, 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 but this kind of a power to punish can be given to the High Court or to the subordinate courts or to tribunals that are functioning in the entire country. So I believe that is what judicial power is in India, and this clearly, vests with the court the power of what I call as judicial review of administrative action, and hence the constitutionality of legislations The constitutionality of executive orders or actions, both at the center and the state, are finally to be examined by the courts, and the courts will probably determine the legality, courts will determine the constitutionality, courts will determine the validity of any such legislative and executive actions. And hence, what is not going to be enforceable as a matter of public policy under the constitution is something that the judiciary will always intervene, test, and probably set the tone as the case is. Um, Now, when you talk about the Supreme Court of India, please note the Supreme Court has actually performed very other numerous functions, or what we can say has other numerous duties to intervene. For example, very often than not, where the government has altered the qualifications or age of the election commission and election commissioners. In those matters, finally, the the thing whether the government has done it right or wrong is going to be decided by the Supreme Court. The Supreme Court is the final authority on all positions that are considered to be constitutional positions, be it the position of the governor, the election commissioners, be it the role of, Central Vigilance Commission. It could be also in terms of determining the age and qualification of members of the Public Service Commission, because public service commissions are those bodies that actually select the executive branch of the government, and hence what should be the set of criterias, when can they be disqualified. The Supreme Court has rendered a lot of service that has helped the government decide all of these matters. Um of course, the Supreme Court has always agreed that it need not be always correct, and hence the court is willing to review its own decisions. And hence, what was decided sometime, say, in 1980s, can now be reviewed, and there could be a course correction as the case is. So that is where the courts or the judicial decisions have the beauty of it. The beauty is that nothing of the court decision is going to be permanent. It is permanent for the time being. However, once the review happens, it can probably change as well. Now, the courts, generally entertain petitions. You can withdraw the cases in case if it's a civil case, it's a private case. You can ask the court to transfer the case from one court to another, because that is what judicial review of judiciary happens. Because in many matters, the litigants say that they do not have confidence on a particular judge or a particular forum. They want the case to be transferred from that place to another place. Sometimes they will say that the forum is inconvenient, and hence the cases have to be transferred. For example, under the Family Courts Act, the place where the divorce litigation will happen is the place where the lady resides or where the marriage has took place. So it is a forum convenient for women. That will be the forum where the family matters will be decided for. So such kinds of transfer of cases or review of the judicial work, which is usually an administrative function of the Supreme Court and the various high courts keep performing those administrative functions as well. So that is always two sides of the judiciary: judicial function as against administrative functions as well. Yes, I think one thing that you have to note here is that the Supreme Court also is involved in what we call as the supervisory jurisdiction over tribunals. Now, tribunals, or what we call as tribunalization, has happened in India post the 1990s. So we have created these quasi-judicial bodies or statutory bodies who adjudicate disputes. These are specialized bodies created under those law. For example, under the Right to Information Act 2005, we have created the Information Commissions. What is the role of the Information Commission? They have to decide about the implementation of the RTI Act 2005, whether the information ought to be given or not to be given, whether the denial of information was done intentionally or not. So these are tribunals that are functioning under a specific legislation. However, the proper court, that is the proper judiciary, is always a supervisory body over these tribunals. They can decide whether the tribunals are doing right or wrong. They can decide who should be part of this tribunal or not, etc., etc. So all those functions, which we would call as the superintendence and control over all these tribunals within that particular territory, is there with the High Court, and within the territory of India, it is there with the Supreme Court of India. Also, you should not forget the other, different functions that the Supreme Court does from time to time. For example, the Supreme Court has a special examination for lawyers to practice before the Supreme Court. This is called as the, Advocate on Records examination. So those who want to appear in the Supreme Court have to pass this examination. They are considered as advocate on record. They are the only ones who have the right to file cases in the Supreme Court. Making that examination, giving those kinds of designations to lawyers are something that the Supreme Court does from time to time. Does the Supreme Court engage itself with the bar council, which is the body of lawyers or advocates, as we want to call it? The answer is absolutely yes. You will notice that among the advocates in the bar, every year or once in 2 years, the courts decide or designate lawyers as senior advocates. Now, generally a designation of a senior advocate is to someone who is a distinguished practitioner in that court, and he is someone who is considered to have achieved some kind of a degree of success and has a standing before that particular bar, and hence the judges actually are the ones who decide the designation of a senior advocate as well. So these are some of the very interesting functions that the Supreme Court does from time to time, and I think those are some very interesting aspects of what the judiciary is all about. Now, has the Supreme Court come up with some principles of constitution interpretation? Now, you know that the Constitution is a written document. You know that the Constitution is quite a large document. However, as the English language that is used in the Constitution may have, every word in that may have more than one or two kind of meaning in the context of which it is being used. Or maybe there needs to be an application of that kind of an article in the Constitution. The Supreme Court has come up with some very interesting doctrines and principles for what we call as the constitutional interpretation or the reading of the Constitution. What does this do is that this principles and doctrines, they put the Constitution into working, make it workable, and that's why the process is constitutionalism, and this kind of gives the Constitution some kind of an application role. So some of the important doctrines that have been evolved by the Supreme Court are the following. First, there is something called the doctrine of severability, the doctrine of waiver, the doctrine of eclipse, the doctrine of territorial nexus, the doctrine of pith and substance, the doctrine of colorable legislation, the doctrine of implied power, the doctrine of incidental or ancillary power, the doctrine of precedent, the doctrine of occupied field, the doctrine of prospective overruling, the doctrine of harmonious construction, and finally the doctrine of liberal interpretation. Yes, these are what is there in the Constitution, and of course, while you would like to compare the Indian Supreme Court with the American Supreme Court, quickly let me just tell you that the American Supreme Court does not have the advisory jurisdiction, whereas the Indian Supreme Court does have. Interestingly, the appellate jurisdiction of the American Supreme Court is only for constitutional matters. In India, it's a wide ranging of matters, right? So there are a lot of distinctions between how the Indian Supreme Court functions and how the American Supreme Court functions. Right, of course, both protect fundamental rights, and that is the reason why they are called supreme in the other sense. In India, the judges of the Supreme Court have a retirement age, whereas in the American Supreme Court, the judges do not have a retirement age. They are judges for life. So they would either end their tenure on their death or until the time they would like to resign from their job. Now, coming to judicial review, friends. Now, the doctrine of judicial review, it's called the doctrine of judicial review, was also developed in the United States. It was for the first time propounded in a very famous case called the Marbury versus Madison case of 1803. It was delivered by the then Chief Justice of the American Supreme Court by name John Marshall. Now, in India, the judicial review is something that we have to give to the constitutional courts. And this, as I told you, has been also said to be the basic structure or feature of the Constitution of India. And this kind of a power cannot be curtailed or cannot be excluded by any constitutional amendment. What is judicial review? Friends, judicial review is the power of the judiciary to correct and keep a check of law that are being introduced by the executive and by the legislature. Now, one must understand that it is not only the legislature that makes law, it is the executive that can also make law. What law is made by the legislature is called, usually, they are called as substantive laws. And the name of these are in the frame of an act. Whereas delegated legislation, which means the act has to have rules, regulations, guidelines, notifications, circulars, etc., etc. These put the act in force. They make the act implementable. Now, most of these laws are made by the executive. So, Article 13(3) of the Constitution defines law to include act, rules, regulations, notifications, circulars, bylaws, and so on and so forth. So, these are all laws. And all of these laws that are made either by the legislature or by the executive can be part of the doctrine of judicial review, right? So, I think historically, judicial review has been able to protect liberty and has been able to establish what we call as the limited government and maximum governance. So it has enhanced the efficacy of legal bindingness. The respect for law has definitely come about, and it is important that the judiciary tries to keep a check on the two other organs of the government. And wherever there is some kind of a conflict, the court must resolve those kinds of conflict. So the limitation of government is probably the attempt of judicial review, right? And of course, judicial review of administrative actions are not only limited to state governments, it can also extend to union government. It can also extend to local governments, as the case may be right now. We have the municipalities, we have the panchayats, and so on and so forth. So all of these can actually be brought into existence. Interestingly, what has judicial review done? It has also checked policies or policy consideration. So the policy is some kind of a vision statement. It is some kind of a policy of welfare. It could be an economic policy. It could be a social policy. Whatever be the policy, I think judicial review of the policy has always taken place, and the courts can decide whether the policy is in tune with the constitutional mandate, is the policy in tune with public policy or not. I think these are certain aspects that the courts can intervene, though they would not want to do so. From time to time, they have said that we don't want to intervene in public policy matters, but they can definitely check whether the policy has been made with the authority to make it, whether it is sound or does it result in any kind of violation of constitutional rights. Now, one of the policies I just want to highlight over here, which underwent judicial review, was the most famous policy of bank nationalization that happened in 1970. So some of the banks that were private were nationalized by the government. Of course, this was the time when socialism was at its peak. Whether that kind of a nationalization is appropriate as per public administration, as per public policy of the land, the court said, yes, of course it is. So that was also part of the judicial review process. So what does judicial review do? It maintains the principles of the supremacy of the Constitution. 2, it talks about maintaining federal equilibrium between the center and the state. And 3, it protects fundamental rights. And that is what is the purpose of judicial review, as the case may be. Now, the importance of judicial review was laid down in the Keshananda Bharati case, where Justice Khanna said that judicial review has thus become an integral part of our constitutional values, and the power has been vested in the High Court and the Supreme Court to decide the validity of the provisions of certain statutes. Right? So, striking down certain provisions which violate the constitutional principle is an inherent power of the judiciary.